Pacta Sunt Servanda is a Latin maxim, which literally means that agreements must be kept. It is embodied in Article 26 of Vienna Convention on the Law of Treaties, which states that every treaty in force is binding upon the parties to it and must be performed by them in good faith. Therefore, a contracting party will be held responsible for breach of a treaty. In a legal system that depends largely upon freely given consent as the basis of legal obligation, it is axiomatic that fundamental legal consequences will follow upon such free expressions of consent. Pacta Sunt Servanda articulates the most elemental of such consequences in asserting that unconditional consent, even though unilaterally given, cannot unilaterally be withdrawn. In the specific context of treaties, Pacta Sunt Servanda simply means that, once an international legal subject has expressed its consent to be bound by a treaty and the treaty has come into force, the treaty is binding on that subject and must be performed by it in good faith. In other words, even a sovereign state cannot invoke its sovereignty to renege on its treaty obligations. International Court of Justice stated in Hungary v. Slovakia that Article 26 of Vienna Convention on the Law of Treaties combines two elements, which are of equal importance. These two principles are the principle of Pacta Sunt Servanda and the principle of good faith. Indeed, each time when a state is in breach of the principle of Pacta Sunt Servanda, it also violates the principle of good faith. If a state does not perform its obligations deriving from a treaty, it breaches both principles. Contrary to the principle of Pacta Sunt Servanda, which applies only to treaties which are in force, the principle of good faith is all-encompassing as it even imposes obligations on a state in the pre-ratification stage. In this respect, Article 18 of Vienna Convention on the Law of Treaties requires a state to refrain from acts which would defeat the object and purpose of a treaty in a situation where a state has signed a treaty but not yet ratified it, or when it has ratified it, but it has not entered into force. The principle of good faith applies throughout the life of a treaty, from its negotiation, through its performance to its termination. Furthermore, according Article 31 of Vienna Convention on the Law Treaties, treaties must be interpreted in good faith not only by contracting parties, but also by third parties such as arbitrators, international courts, and domestic courts. While enshrined as a matter of treaty law in the Vienna Convention on the Law of Treaties, the Pacta Sunt Servanda principle is first and foremost a rule of customary international law. In fact, it is so well established and so essential to the whole architecture of the international legal order that it could be considered a preeminent example of a rule of jus cogens, or a customary rule from which no derogation is permissible. That a treaty must be performed in good faith usually entails executive or legislative action by each party to the treaty within its own domestic legal or constitutional system in order either to ensure that the party is able to perform the obligations assumed under the treaty, or to give the treaty domestic legal effect. A state's government will presumably be required to adhere to the dictates of its own domestic legal order, including, but not necessarily limited, to the requirements of its constitution. However, when viewed from the perspective of international treaty law, and of the principle of Pacta Sunt Servanda, such domestic legal impediments to implementation or performance provide no escape from the basic international legal obligation of good faith performance. In other words, a failure to perform a binding treaty obligation, even due to a domestic constitutional obstacle, will constitute an international legal wrong, potentially giving rise to an international claim for reparations by other parties to the treaty. This basic and necessary corollary of the Pacta Sunt Servanda principle has been codified in unconditional terms in Article 27 of the Vienna Convention on the Law of Treaties. This article provides that a party may not invoke the provisions of its internal law as justification for its failure to perform a treaty. The Law of Treaties asserts that domestic law cannot dictate the existence or extent of international legal obligations undertaken in good faith by way of treaty. This is not the same thing as saying that states must violate their internal law in order to perform any conflicting treaty obligations they may have. International law rarely dictates how a state must behave within its domestic legal order. Rather, treaty law provides that a conflicting domestic legal rule provides no justification for a failure to perform treaty obligations, meaning that if a state chooses to respect its domestic law by breaching its treaty obligations, it will be internationally responsible to other parties to the treaty for its breach.